Now that we've said that the laws of war are as old as war itself, what are the contemporary rules of war and how did it come to be? International humanitarian law is a branch of public international law that regulates the conduct of armed conflict between states and aims to protect people by defining rights and obligations of parties involved, guiding their actions during conflicts. As discussed in previous episodes, laws of war have always existed to limit the destruction of war. However, despite the universal concern to limit destructive behaviors of war, attempts to restrain warfare have faced setbacks. It was not until the 19th century that a movement to codify the laws of war began and modern international humanitarian law was born. The Lieber Code, established by the United States during the American Civil War in 1863, represents one of the earliest attempts to define the rights and responsibilities of belligerents in armed conflicts. But the development of modern IHL gained momentum with the adoption of the Geneva Convention in 1949. These landmark treaties, inspired by the horror of World War II, established fundamental principles for the protection of civilians and combatants during armed conflicts. Building upon the Geneva Conventions, additional protocols were adopted in 1977 to address emerging challenges and strengthen protection for victims of armed conflicts. These protocols expanded the scope of IHL to cover both international and non-international armed conflicts, providing greater safeguards for civilians caught in crossfire. Yet, despite this accomplishment, international humanitarian law and the humanitarian understanding of the jus in bello remained controversial for almost 2 decades as states and legal commentators questioned the protocol's principles and authorities. It was only at the very end of the 20th century that practitioners of international humanitarian law, following the example set by human rights organizations, accepted the authority of Additional Protocol 1 and with its humanitarian vision of the jus in bello. Over time, customary international law has complemented treaty law in shaping the principles of IHL. Customary practices and norms that reflect the shared values of international community have become binding on all states regardless of whether they have ratified specific treaties. However, international humanitarian law is not a simply historical code managed by states and promoted by the International Committee of the Red Cross. Rather, it is a relatively new and historically contingent field that has been created, shaped, and dramatically reinterpreted by a variety of actors, both traditional and unconventional. Now that we've explored the evolution of international humanitarian law, what are its core foundational instruments?